Mr. Quick was a nurse in a home for people with disabilities. He was also an insulin dependent diabetic, and it seems like he wasn't great at managing his diabetes. He'd been admitted to hospital no less than 12 times in a diabetic coma. On this particular day, he started his day with the breakfast of champions, whiskey and a quarter bottle of rum. He didn't eat much breakfast or much lunch. Around 4 o'clock, he was in the TV room with another nurse and a paraplegic patient. The patient was assaulted, apparently by Mr. Quick, and left with black eyes, a broken nose, a split lip, and bruising. Both nurses were charged with assault causing actual bodily harm. Quick's defence was that he had acted as an automaton. That is, he had been in the throes of a hypoglycaemic diabetic attack and had no control over his actions. A medical expert supported this argument, stating that it was not unusual for a person having such an attack to be violent and aggressive as a result of the attack. In the trial, the judge treated the diabetes as a form of unsoundness of mind, and so the judge ruled that if the jury considered Mr. Quick's conduct to be automatic, he should be found not guilty by reason of insanity. Mr. Quick appealed on the basis that he should be found not guilty outright. The principle is that a person cannot be criminally responsible for conduct which occurs independently of their will. The Court of Appeal agreed. Their Honours said, had the defence of automatism been left to the jury, a number of questions of fact would have had to be answered. If he was in a confused mental condition, was it due to a hypoglycaemic episode or to too much alcohol? If the former, to what extent had he brought about his condition by not following his doctor's instructions about taking regular meals? Did he know that he was getting into a hypoglycaemic episode? If yes, why did he not use the antidote of eating a lump of sugar, as he had been advised to do? However, they concluded that these questions should have been left to the jury, and if the jury found that Mr. Quick's conduct was automatic and that his condition was not self-induced, then he should have been found not guilty.